When it is your turn to give evidence in court, the court officer will call your name. They will then take you and your support person into the courtroom. You will stand in the witness box and swear an oath or make an affirmation to tell the truth. In some cases, you'll be asked to give your full name and address. If you don't want to give your address because you are afraid of the accused finding out, tell the prosecutor beforehand. It is very important that you tell the truth during all court proceedings. While people do make mistakes, to deliberately lie under oath is called perjury and is a criminal offence.
At a murder hearing in the Supreme Court, Nicole steps up to the witness box.
Step into the box, face his honour. Affirmation, Your Honour. Silence, please. Do you solemnly, sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, nothing but the truth? To adopt this affirmation, please say the words, I do.
I do.
The first part of your evidence is known as evidence in chief. It's at this point the court hears all the evidence against the accused, including your evidence. You will be asked questions by the prosecutor about what happened to you or what you witnessed. These questions will be based on what you told the police in your statement.
I was at home making dinner and I heard a knock at the front door. I opened it and I saw Jack. He said he needed to talk to me and I told him to go away and I shut the door in his face.
And what did he do when you shut the door?
He got really angry.
The prosecutor is not allowed to help you with your answers in any way. If they need more information or more details, they'll ask more questions. If you don't understand the question, ask for it to be put another way.
Did Jack ever say that he wanted to hurt Dan?
Yes, he said if you don't let me inside, I'll smash the door down and I'll smash Dan's face in.
Giving evidence can be very confronting. If you have been a victim of personal violence or witnessed a violent crime, you'll have to describe in detail what happened during the assault. This can be very difficult, as it may bring back a lot of feelings that you had at the time of the crime. You may be asked to identify clothing, jewellery or other items, and these will be presented to the court as exhibits.
Yes. Jack had one just like it. He used to put it in his pocket whenever we went out. It scared me. I hated it, but he said he needed it to protect me.
Why did he need it to protect you?
He was jealous. He reckoned every guy was trying to crack onto me. And when we were together, he'd go nuts if a guy even looked at me.
So do you think Jack was mentally unstable?
Objection. Leading the witness.
Withdrawn.
Sometimes the defence lawyer will say, objection, about the way the prosecutor is asking you questions. Don't take the objection personally. It is up to the judge or magistrate to decide if you can be asked the question and how it is to be asked. Just wait and you'll be told when to continue. Sometimes you may even be asked to wait outside while the judge decides whether the question is relevant. The next stage of giving evidence is called the cross-examination, and this is where the defence barrister or solicitor asks questions of the prosecution witnesses, including you. This is a vital part of any trial, as it enables the defence team to test the evidence you have given. It's the defence barrister's job to test your evidence. If you have a break during cross-examination, the judge will remind you not to discuss your evidence with anyone. This means you cannot talk about the questions you are being asked or the answers you are giving with the support person, prosecutor, police, family or friends.
You say that you heard the sound of two men fighting outside your door. Did you see the two men fighting?
No, but I heard Jack yelling at Dan and then he pulled out the knife and stabbed him.
Did you actually see the two men fighting?
No, I didn't.
The defence team could use legal phrases like, I put it to you, or I suggest to you, which may not even sound like a question, but it is, and it requires a response from you. This is where you may feel a bit anxious or uncomfortable. Be prepared to be asked questions that you weren't expecting. The defence barrister may also suggest you're confused, untruthful, exaggerating, or even lying. You may feel upset or angry, but remember, it is not a personal attack. The defence team are simply doing their job, which is to test the information you were giving about the incident. Stay calm and remember to take your time when answering any questions.
I put it to you. That was Dan that attacked Jack. Jack was simply defending himself.
No, Jack attacked Dan when he came home from work.
But you just said that the door was closed and you didn't actually see the attack.
Nicole's tearful.
Dan was a martial arts expert, wasn't he?
Yeah, he taught Muay Thai, kickboxing and karate classes, yes.
In fact, Dan won the New South Wales state title in Muay Thai kickboxing. So he knew how to defend himself, didn't he?
Yeah, but he was a very gentle man. He would never hurt anyone.
And he even incorporated knife and sword work in his martial arts. Isn't that correct?
Yes.
So he was trained to disarm an opponent. Is that right?
Yes.
I put it to you that Jack was acting in self-defense because he believed that Dan was going to attack him using his martial arts skills, because he was jealous that you may have been seeing your ex-partner behind his back.
That's not true. I have an AVO against Jack. Why would I want to see him? Dan would only want to protect me.
So you are saying that Dan would resort to violence to protect you from Jack?
He would want to protect me, yes.
You could be asked about your personal life or about things that you did or experienced a long time ago. Remember, always tell the truth, even if you think it might not help the case. Listen carefully to the questions and only answer exactly what you are asked. And if you don't understand the question, ask it to be rephrased. If you don't know an answer to a question or can't remember something you were being asked about, just say so. And if you feel unwell or too upset to continue, ask a magistrate or judge if you can have a break.
Had a history of violence against other people, didn't he?
I don't know what you're talking about.
I put it to you that Dan got into a violent fight with another man in a pub 4 years ago.
I wasn't with Dan 4 years ago.
Is it fair to say that Dan was a violent man?
No, Dan wouldn't hurt anyone. Look, why is this relevant?
Please answer the question, Ms. West.
Nicole nods.
Miss West, were you aware that Dan was in a violent fight with another man in the past?
Yeah, no. I'm sorry, can I please have a minute break?
We'll take a 15-minute break.
Thank you.
Your evidence may run over more than one day. If that happens, it is very important that you don't talk to anybody at all about the evidence you have given. This includes family and friends. Even the prosecutor can't discuss your evidence with you once you have started cross-examination. Once the defence barrister is finished, the prosecutor may want to ask you some more questions about what you just said in cross-examination. This is called re-examination.
Nothing further from this witness, Your Honour.
Very well. You're excused. Thank you for your time.
When you have finished giving evidence, the judge or magistrate will say, "You are excused." You can now go home, or you may want to sit in the public gallery at the back of the courtroom and listen to the other witnesses. When all the evidence from both the prosecution and the defence teams has been given, the lawyers will make their closing addresses. In most cases, journalists will be allowed to sit and listen in court. They are allowed to write down what is said and report it on the news. In New South Wales, court cases are generally open to the public and the media, such as newspapers, TV and radio, although they don't allow cameras in the courtroom. In some cases, such as those involving children or serious sexual assault, the public and media may be excluded from the court while you give evidence. Talking to the media while the trial is underway could affect your case, so seek advice from the prosecutor, the Witness Assistance Service or the police before speaking to them. In sexual assault cases, your evidence will be recorded and can be used again in a later trial if needed. This is so you don't have to come to court and give evidence again.